Good morning, everybody. YouTube live presentation number 8 out of 20. Doing 20 unique estate planning YouTube live presentations, all different, 20 consecutive days. This is day 8. Gonna be a good one, an important one. Probably not gonna be a real long one. So let's jump right in. I always like to start these with questions that have been posed on my YouTube channel over the last 24 hours or so. Had a question. I don't really understand what they're asking, so I'll go on to the next one. Let's see. We've got someone saying that they've been binge watching and they can't help it. I'm learning so much about all the estate planning steps. Thanks for educating. Another one. This was very helpful. I had no idea about the importance of naming the trust. Thanks for your generosity. Here's a good one that came up about, I guess, about a no contest clause from Lee, who said, what if it's a simple 4-way split, but you suspect 2/3 of her estate is not accounted for? Then the will and trustee contract say if we question her accounting, we forfeit our share. Then do we wait to get our money to afford an attorney, or do we do it now before it's all said and done? So good question. It has to do with the no contest clause. Apparently some people in their wills, they say something to the effect that, excuse me, if any of the heirs or beneficiaries contest the validity of this testament, of this trust, or something to that effect, then that heir or beneficiary forfeits his or her right to inherit. So question, tough question to answer. Their states, each state has different, many states are different as to their validity and effect of these no contest clauses. Here, and I'm just speculating here, looks like you have all the estate planning documents that say things go to the 4 heirs equally, and then the person who was in charge of making sure it went to the 4 ways, went 4 ways equally, may have run off with 2/3 of the money. Now, I will say, and again, a state law specific issue, check with somebody in your state. Don't rely on me. I'm just telling you generalities here. But many of, if you live in a state where no contest clauses are valid, many times they're valid if the no contest clause says that if the validity of the will, or if the validity of a provision of the will is contested, then the person doesn't get anything. But this might be a different matter. This is a matter on questioning the accounting of the successor trustee or the representative of the estate. And I would think that some states, even that give effect to no contest clauses, still allow people to question the accounting of the person who's handling the estate. So that's what I got. Hope that helps. Good morning, Alex. Great to see you on the live chat. Great to see anybody on the live chat. Another question or two before we get into it. Lynn, 20 hours ago, said, do you know if it's legal to handwrite a will in Florida? I'm in Louisiana. Apparently you're in Florida, but my limited knowledge of Florida, it's one of those states where, well, let me give you the long 30-second answer. I think about half of our states permit handwritten wills in a way that they don't have to be notarized or witnessed. If they're in your, all of it's in your handwriting and you meet other requirements like it's signed and dated, then it's a valid will. Other states don't allow that. But, like all states, Florida has a rule that says your will must be in writing. And I'm sure 99.9% of Florida wills are typed up, because that's what we do. We use computer programs and word processing to make it easier to get these things done and revised. And a Florida will, to my knowledge, a disclaimer here, I've never done a Florida will, but my understanding is a Florida will needs to be witnessed by 2 people. Now, so all Florida wills are typed up. It is valid to do a handwritten will in Florida because that meets the writing requirement, but you still got to meet the other requirements of witnesses. And if your state requires notary, that handwritten will would have to be notarized. So you don't see many people in those types of states where you still need the witness or perhaps also notary requirements, doing that in handwriting. Handwriting is typically done where you live in a state and there is no notary or witness requirements. You can do it by yourself. And again, be careful with that, because making it valid is easy. Using the right wording so that there's not problems in the future is hard. All right, so let me see if I have any more in the last maybe 24 hours or so. I got a kick out of one comment. Not everybody loves me. Genevieve said on a comment, "You talk too much and I didn't learn anything on that." In fact, that was in response to a handwritten will video post that I made. But everybody else has been real nice. Okay, here we go. What's involved in a probate? Probably going to run 15, 20 minutes here. Probates take place every single day, at least every business day, in every state, because that's what happens when people die and they own assets in their name. Not just any assets, because, and I'll distinguish between what assets require probate and what don't here in a minute. But, you know, some of you might be saying, you know, from square one, what the heck is a probate? And here in my state of Louisiana, it's often called a succession. To get technical with the probate term, if we're technical, we would say a judge probates a will, which means a judge declares that the will is a valid will and then goes on to the next step in the procedure. But most people envision probate as just the entire process of settling someone's estate. So that's what I'll refer to it as. All right, and it's done through the court system, and that's just the way it is, and it has always been that way, and I don't know how long it will continue to be that way, but it's just been determined a long time ago that our courts, our judges, our judicial system, our government is going to oversee the settling of someone's estate when they die. Okay, what's good about it? What's good about probate? Well, you know, judges are involved, so if necessary, judges can rule on certain matters in an attempt to get things right, which provides a mechanism to get, you know, grievances aired. And as you might imagine, there are grievances in settling estates, because dear Abby said, if you want to get to know somebody, share an inheritance with them. So that might be what's good about probate. What's bad about probate? Same thing. Judges are involved. And so when you're getting, you know, elected officials and judges and courthouses involved, you're starting now down a road of having lawyers involved, and then you're going down a road of delay and expense and aggravation. And sometimes if all of the parties that are involved just are not up to speed on everything, it starts tearing down relationships of siblings, of heirs, of children and grandchildren, in-laws. And so that's the rough part about it. So now what I want to do is I want to go through the steps. And really, I want to go through the steps in the terms of how can a probate be handled in a way where the relationships don't go sour. The ones where, you know, dealt with one this past week. Mom died, 3 kids, they all get along. They don't even care about the money. The probate's going to be relatively simple. Everybody trusts each other. Everybody loves each other. It's going to be easy. And then you got the ones on the complete other end of the spectrum where dad dies, 4 kids. In fact, one I dealt with years ago, the 4 children each had their own security guard at dad's funeral. And so that's the opposite end of the spectrum. Nobody likes anybody. Nobody trusts anybody. And that one was, as we all predicted, turned into a nightmare lasting years, with maybe even dozens of lawyers involved, and just a complete train wreck. But really, I'm kind of talking about this middle of the road, relationship-wise, probate, where somebody dies, you have a group of people, maybe they're siblings, and maybe they're not, but they're at least amicable at the start. And so how can we do that probate so it remains at least amicable, if not, you know, gets even better from a relationship standpoint, instead of just going south where, you know, everybody lawyers up and nobody ever talks to anybody ever again. Okay, so here's some steps, maybe 5 or 6 steps that are really, really important. I'm going to talk about the overriding theme of communication along the way. I'm going to talk about that several times, but probates usually kind of get some momentum maybe a week or two after somebody dies. Sometimes they gain some momentum an hour after somebody dies. Sometimes they kind of get started months after somebody dies. It all depends on the family, the assets, the circumstances. But again, just speaking generally here, it's usually about a week or two after somebody dies where it's hey, what's going on here with the estate? We got to get some things done. Let's look into this. So I'd say, step number one is determine whether someone had a will, and and review the terms of the will, at least to the extent that you can. I know some wills are written in with terms that are very, very difficult to understand, but to the extent you're a layman person, and you at least have to locate the will, and not just certainly not an unsigned photocopy, certainly not even a signed photocopy. Locate that original will if you can, because that's a big piece of getting the probate done. Locate that original will, and then look through the terms of that will. And mainly we look for two things at the, kind of in the first 15 seconds of reviewing the will. One is, what are the dispositions of the estate? In fact, there may be a sentence in the will that says, I leave my estate to my 3 children equally. Boom, there you have it. Didn't take long to figure that one out. The other thing we look at initially is the appointment of an executor. I name my daughter Linda as executor of my estate. Boom, there you have it. There may be a whole bunch of other stuff in the will, but those are the two things that we typically look for, like I said, in the first 15 seconds. Then we got to review the rest of it to see if there's anything else that's relevant, needs to be addressed. So first thing is finding the will, checking out the dispositions and the executor appointment, and then start communicating. And so when you review that will, you're going to see various people's names in that will. Might be children, might be grandchildren, might be friends, might even be charities or other organizations. And now it's time to start communicating, because if there are others listed in the will, those others may even know it, they may suspect it, or they may just be wondering, so-and-so said that they would, leave me in their will, and I haven't heard anything. So is somebody out there squandering the money that I would otherwise be entitled to a portion of? So that's what's going through some people's minds that are, when the relationships are less than, 100% loving and supportive. All right. So real key for whoever initiates this thing to start some communication. There really isn't any reason to keep secrets. That's where people, when secrets are kept and information's not disclosed and things aren't transparent, that's when people start to question things. They get lawyers. I had a phone call yesterday where a woman called me. Their business is owed money from an estate. They've tried to initiate some conversations with the estate and with the estate's attorney, and nobody's returning phone calls. And so they had to lawyer up to make sure that their amount that they're entitled to gets secured. Okay, so communication, really, really important. Then at some point, probably fairly early in the process, you're going to want to talk to an attorney. In fact, one of the things that people do is they go on my website, they see that they can schedule a free call scheduled for 15 minutes. Sometimes it goes beyond that. But I'd say, if you talk to the right lawyer who can spell things out for you, then that lawyer fairly quickly, after asking some questions, finding out, and maybe even reviewing a copy of the will that you send, along with an understanding of basic assets and what the objectives are, the lawyer can tell you pretty quickly, okay, here's what we're going to do. We're going to do this, and this, and that will settle all of these matters from start to finish and get everything resolved. So you can have that conversation. Either you can have it if you're the one initiating this by yourself, probably even better in the spirit of transparency, is if there's 3 or 4 participants, get everybody on the conference call, get everybody at the meeting or whatever. With COVID now, seems to be more conference call type stuff, and let that lawyer guide you through it. And then in the spirit of transparency all along, either the lawyer or the people initiating this will say something like, well, I'll tell you what, let's get everybody's email addresses. Every email that goes out is going to be an email to everybody. Every reply to an email is going to be reply all. If there's more substantive matters that we need to address as we move along this process, let's get everybody on the phone just like we're doing right now. Let's be very transparent. There'll be no secrets, and we'll get this thing done as efficiently as we can. Now you start to see the heirs start to their shoulders go down. They like that. So again, communication is the key. So when you talk to that attorney, you should get some guidance, not just let's get started, but it's going to be, okay, guys, here's what we need to do. We need to get the original will. We need to get the death certificate. We need you to get us all of the financial account statements. If you have the legal description of your parents or whoever it is, real estate, you need to get that to us. And here's what we're going to do. We're going to get Linda confirmed as the executor. That's going to take about a month. Once she's the executor, we'll get the estate a tax ID number, and Linda can go open an estate account. And there's these 3 counts over here that are frozen. But once Linda's the executor, she can move the money. She can take the appropriate court orders to the 3 different banks. They'll write a check to estate of dad, and Linda will deposit that in the estate account, where, estate funds will sit until we get all of this resolved. Sounds like y'all want to sell the house. So Linda, as the executor, she'll sell the house. The proceeds from that sale will go directly into the estate account. Gonna sell that vehicle that dad owns. So Linda will sell that. Again, the proceeds of that sale will go into the estate account. If you ever have any question about, what's going on with the estate account, let me know. I'll keep you posted on statements and that kind of thing to keep things transparent. And then once, all of the bills are paid, which we'll keep you posted on, and it's time to, make disbursements, we'll go back through the court process, get a judge to order that Linda, as the executor, disperse the funds to the heirs, and we'll keep you posted along the way. You'll see every email, every pleading. If you have any questions, let us know. And then once the judge signs that order, we'll disperse the estate funds to the 3 or 4 heirs. Oh, by the way, we'll probably hang on to about $10,000 because we may have to file an income tax return, a final income tax return for mom's for mom's last year of her life. So once we get that settled and we use whatever of the remaining $10,000 of funds that we have to use, we'll disperse the rest up. Who initiate this can have those kinds of conversations, man, things just go smooth, as opposed to that person who initiates it. Maybe it's Linda, the executor. She never emails anybody. She doesn't respond to anybody's emails, texts, or calls. She's got a lawyer, and the lawyer won't talk to the other people, and Linda won't talk to the other participants. And now, geez, all of the other participants are like, man, Linda is not returning my call. She's in control of this $1.4 million. I'm getting nervous. And so again, everybody lawyers up and nightmare. So communication is the key. So at this point now, we're gathering information. We reviewed the will. We had conversations with the participants. There's a determination, and also fairly early, you can and should start the gathering of asset and debt information, because as part of the getting the estate settled through probate or succession procedure, there's going to have to be an inventory of all of the assets that the person who died owned on the date that the person died. So best way to do that, if you have some type of legal description of their property, great. If you have access to their financial account statements, great. Bank statements, checking accounts, CDs, brokerage accounts, those are all types of things that you need to produce so that the lawyer can prepare the appropriate inventory of assets, or as we call it in Louisiana, detailed descriptive list of assets and liabilities. Also, if they have some debts, whether that's a mortgage or a car loan or credit card debt or any other debt, we want to, we got to get all that information, because those are all additional things that need to be compiled into this inventory of assets and liabilities. So just keep, and again, as you get it and you scan it and you send it to the attorney, copy everybody else so everybody's, informed. There's going to be some determination to made as to whether there needs to be what's called an administration of the estate. So that is common when there's an estate that maybe, has a complication or two. And complication is probably too strong a word. But an administration means you actually go through the formal steps of getting the executor named in the will confirmed, or if there's no will, someone, often one of the heirs, petitions a judge or a court to have themselves appointed as the administrator. Two similar terms, different terms, same roles. Executor is when there is a will and someone names the executor. And administrator, there's no will and then someone petitions a judge to appoint an administrator. Same roles. Their job is to, guide the family through the court process of getting everything settled. So you could also call that person the personal representative, could encompass both the executor and administrator term. And then we've got something in Louisiana we call independent executors or independent administration. I know other states have it too. If the will authorizes it, or in absence of a will, if all of the heirs agree that the administrator can be an independent administrator, then that executor / administrator can take certain actions without having to get a judge to approve every action that they do. But there's still going to be a probate. There's still going to be court pleadings filed. It's just some of the things that that an executor would have to do, like paying an estate bill. Certain things those personal representatives can do independent of court approval or without court approval. So a lot out there written on independent administration. You can look up on that. And I've even made a bunch of videos on it. Okay, we're doing good. Smash the like button. Let's keep going. Finishing up here. We're making great progress. We've somebody died. Somebody found the will. Somebody reviewed the terms of the will for the dispositions and the executor. Somebody started, initiating communications with all of the parties that are involved. That's real helpful. People started collecting asset and debt information so that can be given to the attorney, so the attorney can prepare the inventory of assets and liabilities. There's a determination made whether someone needs to be confirmed as an executor or appointed as an administrator. There was a situation last week where I handled a probate where there was no what's called administration. And that's when it's simple, for lack of a better term. So it was a situation where mom died. Mom had a will leaving everything to the 3 children. One of the children has signature authority over mom's checking and savings accounts. So that account is not frozen. The son can still access it to pay funeral expenses, to pay other bills on mom, to pay, quite frankly, attorney's fees. And then there's the only other assets in the estate were some investments. This was a woman who died who lived in an assisted living facility. And so the woman had no real estate. She had no vehicle. She had none of those things that often require an administration, because things are sold often in an administration. So, but all this woman had was a checking and savings account, which the family has access to, and a couple of investment accounts, which there's no real sense of urgency on accessing those investment accounts. So we don't need to go through the formal process of getting an executor confirmed. The executor, who is the one who has signature authority on the bank accounts, can still take care of stuff that he needs to take care of on behalf of his mother or the estate. We'll just prepare all of the court pleadings, all of the inventory of assets and liabilities. We'll get the heirs to sign off on it, and we'll go just directly, kind of in one shot, petitioning a judge to sign the appropriate order, just ordering that estate assets be transferred to the 3 children. And then when we get that order, they'll take that order to the 2 investment firms where mom had brokerage accounts. Those accounts presently are frozen, but then the probate order orders those financial institutions to transfer mom's assets to the 3 children equally. So the 3 children will each have to set up accounts, their own individual brokerage accounts, at each of those 2 brokerage firms or financial institutions. And then the financial institution, pursuant to the court order, if mom had 90 shares of ABC Inc. stock, the brokerage firm will transfer 30 shares to each of the 3 children's individual brokerage accounts. And that's the way those things get transferred and handled outside of an administration. Could do an administration where, get an executor confirmed, an executor opens up an estate account at those financial institutions, move the assets from the frozen mom account into the new estate account. And that way, if an executor needs to manage those assets, buy and sell assets, if an executor needs to sell investments to pay estate debts, then that could be done as part of an administration. But so anyway, some analysis of administration versus non-administration. And then if there is an administration, which means step 1 is getting either an executor confirmed or an administrator appointed. Once they get confirmed or appointed, we get that executor or administrator a tax ID number. They open an estate account, and they'll pool the estate's funds into that estate account, often for ultimate distribution later. And then towards the end, let's say the family wants to keep the family home, so they don't sell the family home. At the end, we'll get the final court order, which orders the home and other assets that remain to be transferred to the 3 children. And then once the judge signs that order, we get that order filed or recorded in the real estate or land records of the appropriate in our state parish and other places county. And that's what makes the 3 children the new owners of the home. In addition, there's likely to be some kind of maybe final income tax return that needs to be prepared on behalf of the deceased. So for example, here it is June 13th. So if someone were to die on June 13th, they likely have to file an income tax return for 2020, but it can't even be filed until 2021. The 2020 income tax returns aren't even out yet. So hold back some funds and wait to make sure that the executor doesn't have to go ask the heirs to give them some money back, so that final income tax return could be prepared and filed and the income tax paid. So that's a whole bunch of stuff about probate. Essentially, communicate, gather information, determine the existence of an original will, get with a lawyer who will lay out the process, and that lawyer should lay out the expectations the right way, should be able to tell you something like, I don't know how long this is going to take, but if everything goes smooth, it will likely take something like 4 to 6 months. So they ought to give you some guidelines. Now, if there's complications and stuff that comes up that was not envisioned during the initial conversation, that might make things last longer or shorter. But the lawyer should be well-versed enough with their state's probate law and their practical experience that they have to give you an idea of what to expect over the coming weeks, months, or perhaps even years. So there you have it, a probate process. Tomorrow, going to be talking about, similar to the question I had earlier, was about the whole handwritten will deal. Got a lot to say about that. Certain states allow it. Even the ones that allow it, you got to be careful if you do it. So we'll be talking about that tomorrow on June 14th, Sunday. And so pass that word around, maybe for people who don't have wills and people who are interested in figuring out how to get something simple in place. I'll be going through what those states are that allow it, and we'll take it from there. On number 9 of 20 YouTube live presentations will be tomorrow. All right, y'all take care. Y'all have a good day. See you next time.